Mr. President and honorary members of the panel, my name is Brandon Zhang, and I appear on behalf of the respondent, the International Federation de Football, FIFA. I will speak for 12 minutes and respectfully reserve 1 minute for rebuttal. I will speak on two issues today. One on the procedural issue relating to appellant's statement of appeal, and two, the substantial issue on the appellant's refusal to cooperate. I shall now begin with the first submission. We submit that the appellant's statement of appeal is inadmissible for three reasons. First, the day of the receipt shall be 31st March 2026, and therefore renders the statement of appeal is filed late outside of the 21-day limit. And secondly, in the unlikely event that the panel takes the receipt of the date to be the 2nd of April 2026, nonetheless, CAS jurisprudence has held that the timeline extension is a strict compliance and there is no reinstatement. And thirdly, the appellant claims that there was an exceptional circumstance, but has not yet established the high threshold required in the first limb under Rule 57 of the CAS Code. Turning now to the first point. Author Ragozzi, in his commentary in Arbitration in Switzerland on Rule 49 of the CAS Code, states, I quote, "It is sufficient according to standing jurisprudence that the addressee had the opportunity to obtain knowledge of the decision. Whether or not the addressee had actual knowledge of the content of the decision is, on the contrary, irrelevant. In the present case, if I may point the panel to paragraph 23 of the record. Here, the appellant had confirmed he had hired legal counsel on 8th of December. The appellant and his legal counsel would have had the opportunity, therefore, on the 31st of March to obtain the knowledge of the decision, as they were fully aware that on that day the decision would be rendered. And therefore the relevant time period had been established and the appeal had been filed after the statutory time limit of 21 days. And accordingly, we pray that the panel upholds the 21-day statutory time limit and find the appeal inadmissible. Nonetheless, in the alternative, if the panel is not in agreement with us on this point, then we submit that the timeline is absolute and strict, and this has been the CAS jurisprudence. For example, in the 2020 CAS decision of Fawcett Kimberly Smith versus the ITU, the panel observed at paragraph 51, Article 32 of the Code expressly precludes the sole arbitrator from extending the time limit for the filing of the statement. and that the time limit for filing an appeal is absolute and strict, and there's no discretion provided under the code to extend the time limit. And at paragraph 53, the panel held that because appellant had not complied with the deadline for filing the appeal accordingly, the statement of appeal was dismissed as inadmissible. In the present case, the statement of appeal was filed on 5th of May 2026. This falls outside of the statutory 21-day time limit pursuant to Article 58, subsection 1 of the FIFA Code in conjunction with Article 49 of the CAS Code. And moving on to the third and last point. Article 56 provides for reinstatement only in exceptional circumstances. And in the first limb, this requires that the party was prevented from acting by extraordinary circumstances. However, in the present case, we submit that the cyber attack does not constitute an exceptional circumstance. Members of the panel, if I may direct your attention to paragraph 30 of the facts and record. Here we see that an IT provider had stated that their email servers had been, I quote, recently been subject to a cyber attack, I quote, which may have disrupted outgoing emails without necessarily generating delivery error messages. And we submit that this does not establish an actual timeline for which the emails were affected, and here it merely states that it may have affected. And according to CAS Code, the deadline of appeal cannot be extended pursuant to Article R32, subsection 2. And in the 2009 CAS decision of PFC Live LLC versus the UAFE, at paragraph 89, it held that a mere inconvenience were not of a nature to prevent appellant from complying with the deadline. And the panel held that because the appellant filed late and claimed reasons because that it was the holidays and that sending the documents by courier constituted an extraordinary event, it held that that statement of appeal was inadmissible. And presently, we submit that the threshold under Rule 56 of CAS Code has not been established, as the IT provider has merely stated that it may have been subject to an attack. And therefore, we submit that the statement of appeal is inadmissible. Mr. President and members of the panel, If there are no questions, I will move on to submission two.